Support for this podcast is provided by Avalara. As a tax professional, you already know compliance isn't just about rates and returns, it's also about accuracy, efficiency, and protecting your business from unnecessary risk. That's why so many finance teams rely on Avalara. Avalara automates sales tax compliance end-to-end, real-time calculations, more seamless integrations with leading ERPs and accounting systems, and scheduled filing across thousands of jurisdictions. With dashboards and data designed for professionals who live and breathe tax, you stay in control with the information you need in a centralized platform. Free up your team's time, reduce audit exposure, and scale compliance with confidence. Visit avalara.com to learn more. That's avalara.com.
Welcome to Tax Notes Talk, a podcast from Tax Notes, the leading source of tax news, information, and analysis.
Welcome to the podcast. I'm David Stewart, Editor-in-Chief of Tax Notes Today International. This week, tariffs go to the court. The tariffs the Trump administration imposed under the International Emergency Economic Powers Act, or IEEPA, have had their highly anticipated day in court. On November 5th, the Supreme Court heard oral arguments in both cases under consideration: V.O.S. Selections versus United States and Learning Resources, Inc. versus Trump. So what did we learn from the almost 3-hour session? Tax Notes managing legal reporter Caitlin Mullaney joins us now to discuss the arguments and the justices' reactions. Caitlin, welcome back to the podcast.
Hi, Dave. Thank you so much for having me on again. Last week was my first time ever going to the Supreme Court, and it was quite an interesting one, to say the least.
Well, let's start off with setting a baseline of the background. What happened that brought these cases to the Supreme Court?
Absolutely. The basis for the cases were 5 executive orders that were issued by President Trump earlier this year, beginning in February. In these orders, he invoked the International Emergency Economic Powers Act, or IEEPA, that you previously mentioned, to impose tariffs on a lot of imported goods. The statute authorizes the president to regulate importation or exportation to deal with an external threat to the United States' national security, foreign policy, or economy, and a national emergency has also been declared. The crux of this case is whether the language of that statute includes authorization for the president to impose tariffs, as he did. The Supreme Court agreed to take up the case at the beginning of September on an expedited review, after the Trump administration filed a petition for review of the U.S. Court of Appeals for the Federal Circuit's decision that Congress had not delegated the power to tariff to the president in the statute. I think going into the hearings, it definitely felt like the wind was blowing against the favor of the government, and that hasn't changed following the arguments. I believe actually the last I checked, there was less than a 25% chance of the Supreme Court ruling in favor of the tariffs.
Well, let's get into that. Let's talk about what we heard from the court at the oral arguments. What really did they focus in on?
Yeah, it was a really interesting vibe in the room coming into it. There was actually rumors that Trump might make an appearance at the oral arguments, which obviously did not happen, making it a lot easier for security for those of us that did attend. However, we did see Secretary of Commerce Howard Lutnick and the Secretary of Treasury, Scott Bessent, and a few other Congress people in the gallery. A fun fact, Jeanne Mullaney was randomly also in the gallery. He was allegedly there for research on a show that he is doing with Neil Katyal, the attorney representing the private businesses in the arguments. Turning to the bench, overall, I would say the justices seem skeptical of the administration's argument that the power to tariff has been delegated to the president, presented by U.S. Solicitor General John Sauer. Sauer's main argument, that was continuously repeated, was that the phrase regulate importation in IEEPA plainly embraces tariffs, which are among the most traditional and direct methods of regulating importation. We also saw Sauer contend that the major questions doctrine does not apply in this case for the common sense reason that Congress would confer major powers on the president to deal with major foreign diplomatic emergencies. This point was particularly contentious with Justice Sotomayor, who questioned Sauer's argument's reliance on inherent Article II powers, whereas the power to impose tariffs is a quintessential taxation power that has not been delegated. Later, Chief Justice Roberts brought it back to the major questions doctrine, questioning why it did not apply to the administration's argument. And you will now hear that exchange.
Counsel, some time ago you dismissed the applicability of the major questions doctrine, and I want you to explain that a little bit more. I mean, it seems that it might be directly applicable. You have a claim source, an IEPA, that had never before been used to justify tariffs. No one has argued that it does until this particular case. Congress uses tariffs in other provisions, but not here. And yet, and correct me on this if I'm not right about it, the justification is being used for a power to impose tariffs on any product from any country in any amount for any length of time. That seems like, I'm not suggesting it's not there, but it does seem like that's major authority, and the basis for the claim seems to be a misfit. So why doesn't it apply again?
The major questions doctrine also came up later in the arguments when Justice Gorsuch questioned Katyal, the representative for the private companies, as to whether they needed it to have a success of their argument. And that clip is incoming now.
The Constitution says that Congress gets to regulate commerce. And everybody understood that that meant and included the power to tariff. Story, Madison, okay? So that's sort of a problem, right? Regulate is a capacious verb. And then you've got the otherwise language as well, which we've sort of discussed. And just on the plain language, forget about the backdrop of major. Do you need major questions to win? I kind of think you might.
A quick note here to say that in the original version of this episode, Caitlin misstated U.S. Solicitor General D. John Sauer's name. That part has been corrected. So there's a lot of discussion here about tariffs and like a regulatory power. Was there any discussion about the sort of nature of the tariffs and the revenue-raising aspect of that, whether it's a tax or something different?
There actually was a good amount of conversation about whether tariffs should be considered taxation. That was actually the lead for Katyal's argument going into it, that tariffs are essentially taxation. It is a charge to the American people and to American businesses. One point was actually questioned by Justice Barrett to Katyal on what the reimbursement scheme would look like if his argument was successful. I thought that was interesting, not only that she was questioning that, but that she would ask him to create the argument. So I definitely think that plays to the skepticism of the conservative justices that was present on the court that day. And going back to delegation, that was a big principle, as well as Katyal's argument, was that this was just a power that was never delegated to the president. This goes back to Justice Gorsuch's questioning of Sauer about the delegation powers and Congress's delegating powers to the president, and basically how it's a one-way street. You're never getting those powers back. Yes, Congress technically can take powers back, but they're not going to. A president's not going to give back powers to Congress, which would be included in that process. And where does the line draw? How much power goes to the president? How much is delegated? And that was a lot of his skepticism showing with the questioning, in that the delegation, which is the argument present in this case, in that delegation has been given to the president through IEPA, and he has the power to tariff.
You say that we shouldn't be so concerned in the area of foreign affairs because of the president's inherent powers. That's the gist of it, as I understand it, why we should disregard both major questions and non-delegation. So could Congress delegate to the president the power to regulate commerce with foreign nations as he sees fit, to lay and collect duties as he sees fit?
We don't assert that here. That would be a much harder case now in 1790.
Isn't that the logic of your view, though?
I don't think so, because we're dealing with a statute that was a carefully crafted compromise. It does have all the limitations that I just talked about.
You're saying we shouldn't be concerned with. I want to explain to me how you draw the line, because you say we shouldn't be concerned because this is foreign affairs and the president has inherent authority, and so delegation off the books, more or less. And if that's true, what would prohibit Congress from just abdicating all responsibility to regulate foreign commerce, for that matter, declare war, to the president?
We don't contend that he could do that. If it did,
why not?
Well, because we're dealing with a statute, again, that has a whole
I'm not asking about the statute. General, I'm not asking about the statute. I'm asking for your theory of the Constitution and why the major questions in non-delegation, what bite it would have in that case.
Yes, I would say by then you had moved from the area where there's enormous deference to the president, actually both the political branches, where here there's inherent authority, and piled on top of that there's a broad delegation.
You're saying there's inherent authority in foreign affairs, all foreign affairs. So regulate commerce, duties and tariffs and war. It's inherent authority all the way down, you say. Fine. Congress decides tomorrow, well, we're tired of this legislating business. We're just going to hand it all off to the president. What would stop Congress from doing that?
That would be different than a situation where there are metes and bounds, so to speak. It would be a wholesale application.
You say we are not here to judge metes and bounds when the foreign affairs. That's what I'm struggling with. You'd have to have some test. And if it isn't the intelligible principle test or something more with more bite than that, you're saying it's something less. Well, what is that less?
I think what the court has said in its opinions is just that it applies with much less force, more limited application in this context. So perhaps the right to approach it is a very, very deferential application of the intelligible principle test, that sort of wholesale application of.
All right, so now you're admitting that there is some non-delegation principle at play here, and therefore major questions as well. Is that right?
Very limited, very, very deferential. Okay. Limited is what, and again, the phrase that Justice Jackson uses, it just does not apply. At least
I know, but that's where you started off, and now you've retreated from that, as I understand it.
Well, I think we would, as our frontline position, assert the stronger position, but if the court doesn't accept it, then if there is a highly deferential.
Can you give me a reason to accept it, though? That's what I'm struggling and waiting for. What's the reason to accept the notion that Congress can hand off the power to declare war to the president?
Well, we don't contend that. Again, that would
well,
be...
you do. You say it's unreviewable. There's no manageable standard, nothing to be done. And now I think you... tell me if I'm wrong. You backed off that position.
Maybe that's fair to say.
Okay.
We are excited to announce the expansion of the Tax Analysts Awards of Distinction, recognizing individuals and organizations whose work has had a significant and lasting impact on tax law, policy, administration, or public understanding. The next category, U.S. federal taxation, is live. We are currently accepting submissions to honor contributions of measurable impact in the federal tax field. The future of tax policy starts with bold ideas and bold leaders. Nominate now through January 30th. For more information, visit awards.taxanalysts.org. Again, that's awards.taxanalysts.org. So what did the government emphasize in their case trying to support the idea that this power does belong to the president?
Sauer's main argument was that the power to tariff is included in that power of regulation. He harped very strongly on the language in IEPA that it was to regulate importation and exportation, and that the only way that those can be regulated is through the tariffs. He brought up a formal case with Nixon where he applied a licensing fee as a regulation tactic, and that was one that he basically was saying there is no difference. And later, coming up, Katyal, his argument was it's just not in the language. The language of the statute does not include tariffs, and if Congress wanted them to, they would. So one interesting thing is Sauer. He makes it very light of the revenue-raising aspect of a tariff. He basically, in defense of the administration's component of it, that it doesn't matter that these are revenue-raising and that the revenue is coming from American citizens and American businesses. So he kind of lowered that. Another point of skepticism came from actually Justice Barrett, and she asked whether there were any other places in the code or any other time that he could think of the term regulate importation being used to confer a tariff-imposing authority, which the only two examples that he could provide were the Trading with the Enemy Act of 1917, which eventually morphed into IEEPA and was also interpreted by Yoshida International, which was the predominant case that he used for the basis of his argument. And you can actually hear Alito pushing back on that position in this upcoming clip.
The CCPA said things in Yoshida that are helpful to your position, but it also said some other things. It said that future surcharges, quote, must of course comply with Section 122 of the Trade Act of 1974. And it said that the Trading with the Enemy Act did not authorize the president to, quote, fix rates of duty at will without regard to statutory rates prescribed by Congress. So do you think that Congress, to the extent Congress had that decision in mind and relied on it, do you think it also relied on those statements in the opinion?
Is it a bit inconsistent, the position that Sauer's taking in front of the Supreme Court, that the revenue is not a major factor in this, while at the same time the administration is making a very large deal about it in public, that the revenue being raised by these tariffs is going to do many things?
It's actually an extremely inconsistent opinion, and it's one that has been brought up by the businesses and the states that are going against these tariffs, and one that continues to go after the arguments have already taken place, and the effect that not having these revenue would affect when there wasn't supposed to be a benefit of the revenue that they were raising.
So what sort of arguments did we hear from Learning Resources and the states challenging these tariffs?
So we heard a number of arguments, far fewer arguments than we heard from the administration, but arguments that from the questions given by the justices seemed to hold a lot more water. The main one was that came from Cadial, who was, as I said, speaking for the private businesses, was the one that he opened his argument with, was that tariffs are a tax. They are paid by the American people. They are paid by American businesses, and that power has not been delegated to the president by Congress under IEEPA. And those executive orders should be rescinded because they are now illegally raising revenue from American people, and that is money that they should not be paying. Another case that we saw brought up by both Justices Barrett and Justice Kavanaugh was the Algonquin case. In that case, the court held that the president was allowed to regulate commerce through a license fee. Cadial argued back with that he was allowed to regulate through a license fee, but rather a license, and that was the difference, similar to here, because a license fee becomes revenue raising, whereas just a license allows for regulation. And you can hear some of Kavanaugh's back and forth in this upcoming clip.
Your argument here is that the statute has to use the word tariffs, I think, basically. And we went through Nixon and Yoshida, but then Algonquin, the statute for 232, does not use the word tariffs. It uses adjust imports. And President Ford had imposed, again, a pretty significant tariff on oil imports. It was challenged. It got to this court. The attorneys standing where you are stood up and said the license fee now before the court involves the broadest exercise of the tariff power in the history of the American Republic. In fact, we would have to go back to George III's stamp tax to determine as broad an executive power as claimed in this case. The statute is a simple one. It does not mention the tariff on its face. The argument there was the word tariff was not mentioned, used to adjust imports. The court, obviously 9-0, rejects that argument, in part because, as others have pointed out, the court does a lot of questioning. Well, what's the difference between a quota and a tariff? And what's the difference between an embargo and a tariff? And so when the court writes the opinion, it says we find no support in the language of the statute, the language, for respondents' contention that the authorization of the president to adjust imports should be read to encompass only quantitative methods, i.e. quotas, as opposed to monetary methods, i.e. license fees, of effecting such adjustments. So, on your basic point that you need the word tariff, Algonquin says you don't need the word tariff.
So as I understand it, they got pretty deep into the weeds on the terminology being used here, licensing, license fees. So what really became of that?
Yes, similar to the license fees, there was a lot of discussion about language. Earlier in the case, there was actually a discussion about like verbs and actual parts of language, which was unexpected, but not unprecedented in a Supreme Court case. There was one point here where Thomas asked Katyal if tariff power cannot be delegated, if his argument on non-delegation would also have to apply to embargoes and quotas. And Katyal disagreed with his argument that tariffs are uniquely revenue-raising and they impose unique concerns because of that. And he does not believe that that would apply to embargoes and that you can go back to our founding as a nation with that concern. And you can hear about that in this upcoming clip.
Embargoes stop the shipment. Tariffs start the tax bill. They are first and foremost ways of regulating revenue. As some of your own opinions said, this is the way we actually chiefly got revenue for the first 100 years of our republic. Tariffs are constitutionally special because our founders feared revenue raising, unlike embargoes. And, there was no Boston embargo party, but there was certainly a Boston Tea Party.
Harkening back to the arguments of language and the delegation powers, the Oregon Solicitor General Benjamin Gutman, who argued on behalf of the state plaintiffs, he had an interesting couple of exchanges with Justice Barrett, where Barrett basically asked him if he believes that under the wording of the statute of IEEPA that the president could essentially just shut down trade with another nation, but would not have the power to impose a minuscule tariff. Her example was 1% tariff. And Gutman, his response was they would not have the power to do the tariff. The president could shut down trade, but because of the revenue-raising aspect and the delegation powers, he could not impose that 1% tariff, despite her argument that even if it was a lesser medicine. Kavanaugh followed up on Barrett's line of question regarding the acts of a rational Congress and one that would give the president the power to completely end trade with another country but not impose a minimal tariff, which led to an entertaining exchange between the two, which you can hear now.
Your interpretation of the statute, as she pointed out, would allow the president to shut down all trade with every other country in the world, or to impose some significant quota on imports from every other country in the world, but would not allow a 1% tariff. And that leaves, in the government's words in its brief, an odd donut hole in the statute. Why would a rational Congress say, yeah, we're going to give the president the power to shut down trade? I mean, think about the effects. But you're admitting that power's in there. Yeah. But can't do a 1% tariff. That doesn't seem, but I want to get your answer, to have a lot of common sense behind it.
I think it absolutely does, because it's a fundamentally different power. It's not a donut hole. It's a different kind of pastry.
And on that power, that's a good one.
So the court heard this case on an expedited basis. Are we expecting to have an opinion in an expedited way?
I believe that we are expecting an expedited opinion in this one based on the writing on the walls. This is a problem that continues to happen. Tariffs are ever present. And like they said, they're affecting Americans. They're affecting small businesses in America. It was one that, they were quick to get it in front of the court. It's also one that we're continuously hearing a lot still from the parties. You can see the administration is constantly talking about it. Organizations are coming out and talking about it. So I definitely think the Supreme Court is looking to get this one done and off their plate a lot quicker.
Have we gotten any sense of timing for when we can expect this opinion?
I haven't heard anything about when we can actually expect it. If I was to just take an educated guess, it would be before the end of the year, because it would make sense going into all of the new things that affect our economic system at the start of the year.
So since we're already in a predicting mode, do we have any sense of how this case might actually come out?
I think that harkens back to how I opened this up, and in a full circle moment, I think it's going to lean in the favor of the private parties. I think just the skepticism of the judges that have previously voted in favor of this. I know one example that was brought back a lot was decisions that were made under Biden and under similar situations, student loan relief, different things like that. And if the court continues to vote in that way, then I definitely think we could see something against the tariffs.
Well, it certainly sounds like we have some interesting times ahead. And thank you so much for walking us through all of what we've heard so far. And we'll definitely have you back when we have an answer.
I can't wait to come back and talk about that, because I'm sure, if anything, it will be an interesting opinion.
That's it for this week. You can follow me online at TaxStew, that's STEW, and be sure to follow at Tax Notes for all things tax. If you have any comments, questions, or suggestions for a future episode, you can email us at podcast@taxanalyst.org. And as always, if you like what we're doing here, please leave a rating or review wherever you download this podcast. We'll be back next week with another episode of Tax Notes Talk.
Tax Notes Talk is a production of Tax Notes. You can learn more about us by visiting www.taxnotes.com/podcast. When major media wants the straight story, they turn to Tax Notes. Thank you for listening, and join us again for another edition of Tax Notes Talk. Tax Analysts, Inc. does not provide tax advice or tax preparation services. Nothing in the podcast constitutes legal, accounting, or tax advice. A full disclaimer is included in the transcript.